Hi, my name is Stephen Lee, and I am an attorney in Chicago who previously was a federal prosecutor and the senior counsel to the Chicago U.S. Attorney's Office's Healthcare Fraud Unit. And I'm very happy to be here today for part two of a two-part podcast looking at Operation Brace Yourself in a real-life case of how lawyers can help their clients through some very difficult circumstances. Now, in part one, we talked about Operation Brace Yourself, how companies responded, and two business owners, owner one and owner two, who decided to shut down their durable medical equipment businesses in 2020 after talking with a biller and a lawyer. Unfortunately, unbeknownst to owner one and owner two, the Federal Bureau of Investigation had already opened a criminal investigation targeting them. Now, I ultimately represented owner one, and I have with me today on the podcast a great attorney, Jonathan Meltz, represented owner two. So one big thing that came up, and I think is useful for people hopefully listening to this, is really just kind of the complexity of the Medicare regulations at issue here. And look, I really do think the big things to keep in mind when dealing with this is like scrutinize what the government says, okay? Because it's very confusing and challenging for anyone to keep up with Medicare stuff, including the government's own people. And that came up really a lot through the trial. Basically, I think the government actually misread a lot of the regulations. I think they misread the Anti-Kickback Statute. And that was a big part of our defense, kind of pushing back on those things. And I think the most clear example of that came shortly before trial, when the government sent us some charts that they planned to use at the trial, including some charts that claimed that our clients had violated certain Medicare regulations that didn't actually exist. Like the government's own people had misread the regulations. They had basically, in two ways. One, they said that some things were improper based on the current regulations as of 2024, but which of course were not in effect back in 2019 and 2020. And second, there was something that were still not even prohibited in 2024 when the trial happened. So we pushed back pretty hard, pretty fast on that. And I will say, we filed a motion, constitutional violations, ex post facto clause, all of it. Again, to its credit, the government did back down the next day and withdraw those charts. But it was a really big thing, I think, to keep in mind, because you really do got to scrutinize this stuff for yourself. Don't just accept the government's version. In fact, even the government's own witness admitted on cross-examination that it was, quote, impossible to keep up with everything for Medicare. Because it is. It's really hard. And again, this also goes back to why the willfulness aspect is so important. People make mistakes. It happens all the time. Even government people make mistakes. Mistakes aren't crimes. Okay, so that was one big thing we had to deal with. Another big thing that we've alluded to is that owner one testified. And that was something that we had decided before trial and were so sure of that I said it in opening statement that he was going to testify. And I thought it was really important because we really wanted the jury to understand things from his perspective, right? Because that's the thing. If you hear about it, when the jury hears during the government's case in chief, it's all how the government has packaged things or put things together with the benefit of hindsight, and constructed. That's what the government found, and they did find lots of problems. They found lots of things that the marketer had done wrong. They found lots of things the biller had done wrong. But really, the core of the trial was not about that. It was about whether owner one and owner two knew that the marketer and the biller were doing all these things wrong, and that some of the things they were doing were very problematic. So the best way to show that is really have owner one explain it for himself, and that's what he did. He testified for 3 days, going through everything. And we are very upfront about that. Everything the government has thrown at these guys, owner one is going to talk about. And we went chronologically through everything to show what he knew, what he didn't know, the mistakes he made, things like that. We went through all of it to really explain things and put things in context. So for example, we actually had him explain his understanding of the anti-kickback statute and actually go through some of the articles that he read at the time. That was important to understand what he was thinking and to show that he did not understand some of the government's theory. Some of it was pretty aggressive. He did not understand the AKS to prohibit some of the things the government thought were illegal. Another big thing that we did was show things like those customer complaints, because we showed, yeah, he did hear about the customer complaints. And here's what he did in response. And we showed that he listened to audio recordings with the customers that actually were different from the customer complaints. And he testified about how he and Owner One actually spoke with some of the customers who actually basically thought like, okay, yeah, actually, you know what? I might have had you confused with another company, things like that. So we really kind of put it in context. And we also showed that the customer complaints were actually a relatively small percentage of the overall stuff. Because if you take it out of context and you hear about 10, 15, 100 complaints, it sounds pretty bad. But not when you realize this is out of thousands, right? Then it's like, okay, it's not good, but it's also not as powerful as the government might have suggested initially. The other big thing we did there was we really went chronologically. So we really got to see it from his point of view and how his knowledge changed and evolved over time. And so we did that. But also the really big thing we did was we talked about that audit letter that came up. Because again, the government had made a big deal of the fact that Medicare had audited, Owner One and Owner Two's business and had sent a letter to their business, kind of pointing out all the problems that the auditor found. The thing is, she sent it to an address that Owner One and Owner Two had stopped using months beforehand. And so they had actually no proof that they actually ever received the letter. And that was one of the big things that we showed. And we pointed that out from the very beginning of Owner One's testimony. Because the government claimed, when we first brought out the idea that the audit letter wasn't there and shouldn't have existed, the government kind of backed, well, it might have happened. It's impossible to find the delivery receipt at this point in time. So when Owner One testified, that's actually the first thing we covered. Because Owner One's wife actually went online and found the receipt herself. Because you have to scroll further down on the webpage to pull it up. And she did. And it really showed that the government had really botched this one part of their case. And in fact, a pretty important part of the case. And so that was a big part of how we kind of went through everything to really kind of show Owner One's story and really try to get the jury to see things from his point of view. And which is extremely important for the willfulness aspect.
I have two quick things on that, Stephen. Number one is that your preparation with Owner One was so thorough and so detailed, and you spent so much time together that by the time you came to court or he came to court to testify, the hard work had already been done, right? You guys really put it together nicely. So that's number one. Number two, because of his testimony was so good and so complete, and it wasn't just me or I, he included Owner Two because they were business partners. So the fact that Owner Two did not testify in the trial is partly true. Remember, because I argued he did testify because Owner One was so complete, so descriptive. And that was because of all the work that you all did together. So it was another, important strategy development by using a unified joint defense, because we had one defendant, one client testify, but he really testified for both because they had done everything in this partnership together.
And that was pretty clear from the first time that Jonathan and I got hired, to be honest, that this was a case where the government's case is pretty much identical against both guys. And so it made sense. Other cases might be different, but this was a case where they definitely stood together or went down together. And it is really important to kind of go through all that. So Owner One testifies 3 days. The government cross-examines him, about 3/4 of a day. Government puts on his rebuttal case. Everyone rests. We do closing arguments. And then the jury gets the case and they start deliberating. And this was a case where they deliberated for a while. So, Jonathan, can you talk about kind of how that unfolded and how the verdict ended up?
Quick break. If you're a healthcare provider or an entrepreneur involved in healthcare and have a legal problem, whether it's compliance, regulatory, DEA, criminal, or any number of legal problems, Chapman Law Group is here to help. Please visit us at chapmanlawgroup.com. Click the link below. Now back to the video.
So whenever somebody has the unfortunate experience of being a defendant in trial, the whole experience is just so much, right? So overwhelming. But once everything is over and it's in the jury's hands, so they're in the room deliberating somebody's future, their destiny, it's unbelievable, the just amount of emotion that goes on. So we hang around the courtroom, we go downstairs, we do these certain things, but we have to be accessible in case there's some issue to get back to court. And I think in this case, the jury had questions or submitted notes to the judge 4 or 5 times. So when we get a call from the court staff saying, can you come back to court? We don't know if it's a verdict or if it's a question from the jury. And I think it was, Stephen, the first 4 times there were questions. And of course, each question has its own, permeabilities and what we want the judge to say to them. But it's all just so much to endure and to absorb. So I remember the last time, I think it was number 5, our clients were going to go out and get something to eat. And then we got a call that there was another note, we thought a note, get back to the courtroom. So we got back and waiting for the clients. Everybody rushes in. Half the family members were there, the other weren't, because if it's just a note, we'll figure it out. We'll come back. But then we're all in the courtroom and the court clerk said they have a verdict. And it was just like, woof, like a drop in an elevator. It was like something so surreal. Sometimes it's worse when you have to plan for something. We had no time. The jury was coming in with a verdict. You're sitting next to our clients and you're just like, we have obviously no idea, but we didn't have the talk that we usually talk. All of a sudden, it's all going to happen. It was something like almost of a dream sequence, I think, right there.
And I remember standing next to my client and basically knowing that his life hinged on what was about to happen. And standing next to him while the judge read count after count, not guilty, to every single count was an amazing moment. For him, owner 2, for us, just to know that basically the jury understood, the jury got it. Especially because there have been indications earlier in jury deliberation that they might not have reached an unanimous verdict. But to know that they did come through and see all that was amazing. And then actually I will say, that Jonathan and I and the government and the judge, we actually all went back and talked to the jurors afterwards to hear their thoughts about the case. And it was very rewarding to hear how seriously the jurors took it, how much they considered the evidence, and how much they got ultimately that owner 1 and owner 2, they made a huge number of mistakes. They made some mistakes in trusting people and things like that, but that they were trying to do the right thing. And that's not willfulness. So that was really great. And really, it's an amazing moment.
I can tell you that we don't have to like our clients to give 110%. We've won a lot of trials. I won a lot of trials for clients I don't particularly like. I don't care. But when you like your clients, and we liked our clients a lot, they're good people, beautiful families, little children that depended on them for their future. When you win a case like this, for clients that you like, it's just even so much more of just an achievement and something that just makes you so fired up and feel so good about what you do.
Yeah, we just want to hope you've enjoyed hearing about this real life example of how people got caught up in a lot of the aftermath of Brace Yourself, how people kind of got misled by people and how they kind of got through a lot of very difficult circumstances through the lawyer and biller you heard about in part 1 and through the work that we did in terms of the criminal case. I really hope that you enjoyed this. Jonathan, any final takeaways for the audience?
I'm so excited now having gone through this again with you. I look forward to our next trial.
All right. Well, thanks everyone, and please reach out if you have any questions. Again, we hope that this has been helpful, and best of luck to everyone.
Take care, everybody.
Thank you so much for watching the video. If you liked it, please hit that like button. It helps the channel. It tells YouTube to show this video to more awesome people like you. Hit that subscribe button and the little bell to the right so that you get notifications of more upcoming videos.